Hey y'all, I'm the loud little ducky, and we are doing part two, basically, of the motion to disqualify David Gingras. David Gingras is Laura Owens' attorney in the Clayton case. He did appear for an initial appearance in the Owens v. Marraccini DVRO renewal case. We covered the motions. Now we're going to cover his blog comments and tweets that are exhibits in his motion to disqualify. As y'all know, tilted lawyer Omar Serrato is representing Marraccini, and let's find out if things that Gingras says on the internet is going to come back and bite him in his ass. So let's jump in. We're not going to read every single comment. If you want to, they're on this page, but we will read all of his comments and some of the questions that he is answering for context. So here, somebody posted, David, I keep forgetting to ask, to win the biggest defamation case in Arizona history, wouldn't Laura have to prove very high financial damages? What are the ways Laura is experiencing financial loss as a result of the defamation you are alleging? Thanks for your correspondence. And that was on May 2nd, 2024. Now, you don't have to have high financial damages. You can just have financial damages. That can happen, but not even. But Gingras says the next day on May 3rd, 2024, Beth, I appreciate the question, and I know you probably think Laura would have to prove high financial damages. That is actually not how defamation works. This area is complicated enough to fill multiple textbooks with all the rules, exceptions, and examples, so let me just give you a very short summary. And this is coming from a guy who has litigated hundreds of defamation cases, which, if he is an internet lawyer, a lot of that is going to be around defamation, slander, libel, stuff like that. In this situation, if Laura wanted to sue Clayton or any of the bloggers/vloggers accusing her of faking her pregnancy, she actually does not have to prove any financial loss at all. The speech in question is so offensive and so inherently harmful to Laura's reputation that it's what we call defamation per se. In a case like that, you can recover actual economic losses, but a jury is also allowed to award money for other things, including emotional distress. Emotional distress is, especially if it's intentional infliction of emotional distress, or maybe it's not, but that claim is so hard to get. The courts usually, a lot of times, if it's not something that's absolutely egregious that somebody said, and there are acts that go, like outrageous conduct that goes with that, it's usually not going anywhere from what I have seen in other cases. You can look at Gabby Petito case. That one ended up settling, and then, there's emotional damages in the Maya Kowalski case. For emotional distress. Then in just defamation cases, there's things like that, but it has to ruin somebody's lives, and truth is always a defense. So none of us are out here saying things that are just so offensive that it's so harmful to her. Like, none of us are out here saying things. um, that we don't have receipts for thinking the way we think. So, harm to reputation, past and future. And here's the key thing: the jury can also award punitive damages that only serve to punish the defendant, which we saw in the Johnny Depp Amber Heard um, trial. If you don't practice in this area, you may not realize it, but if you attack someone the way Clayton and his followers have attacked Laura, the sky is basically the limit when it comes to damages. A jury could easily say that Clayton attacks were so vicious and so malicious that Laura should recover $10 million in emotional distress, $10 million in reputational harm, and $100 million for more in punitive damages. So yes, a judgment of $120 million or more is easily within the realm of possibility. No, it's not. You be drinking the Delulu lemonade. You live in La La Land. She would get nowhere near this because Clayton wasn't being vicious. There was nothing vicious. He had a reasonable reason for thinking this girl is crazy. We didn't have sex. How the hell is she pregnant? I don't think she's pregnant. We didn't have sex, so I don't think this is my baby. And because she gives me no proof that is based in truth, everything she shows me has been a lie or it's been doctored or it's been stolen. I don't believe she was ever pregnant. Definitely not with my child. I don't think she was pregnant with anybody's child at that point. And some states do have it to where you have a cap on like punitive damages. Arizona does not have a cap on their punitive damages. Because that was one of the things I was looking at and thinking, I don't know if she could win that much in punitive damages because that's really, really high. Um, to think that she would win 100 million in punitive damages. No. And don't just take my word for it. Just a few months ago, former New York Mayor Rudy Giuliani was sued for defamation after he said two ladies in Georgia did stuff to rig the election there. His claims were false, and he repeated them over and over and over again, just like Clayton's fans. The two ladies sued Rudy for defamation, and a jury awarded them $148 million in damages. The thing is, when Gingras brings up examples, the problem with his examples is they are apples to oranges and not apples to apples. He sucks at comparing and contrasting. Rudy Giuliani had no receipts or reason to actually factually believe that these two people did what they did. He had a feeling, he he kind of put it out there as fact. There were lots of things that because he said this about them, it ruined their lives in ways, messed with probably their job opportunities because of Rudy Giuliani is a person, of like authority and people look up to him and people listen to him. And if he's saying it, it has to be true because why would he say something that wasn't true? And he did it with reckless disregard. I don't know if he had malice. Um, he might have, but definitely reckless disregard. He had no reason to say this other than this is what he thought. And he relentlessly went after them. That is not what is happening here in the Clayton case. In our Justice for cult, JFC is now Justice for whatever. We are just the Justice for. Okay? And we're not really a cult, but he likes to call us a cult, so we are just the Justice for people type cult. we seek justice and truth here in our cult. And so he has the link there. He says, this just goes to show how online defamation is no laughing matter. Assuming Laura wins this case at trial, which we know she didn't, and she didn't win any of her appeals thus far. My expectation is she will sue Clayton and many others, and I'm guessing 120 mil will be on the low end of what I expect a jury will award. This is never happening. And one other important thing to note, unlike most other kinds of debts, defamation damages awards cannot be discharged in bankruptcy. And we know that you and the Owens family know all about the bankruptcy and how to get around it and get debts erased if you can. That means if Laura sued Clayton for defamation and won, he would not be able to avoid paying her by filing bankruptcy. Clayton's not the one that files bankruptcy. The Owens do because they misuse money. They lie to people. Yes, it's always possible a jury could give a smaller award, but if they come back with something in the tens of millions, the defendants will be stuck paying that judgment for the rest of their lives. Of course, truth is a defense, so maybe if Clayton has clear and convincing proof that everything he said is true, which he does, then he'll be fine. But if I was in his shoes, I would not take that kind of risk. You are not in his shoes, you will never be in his shoes, because you are not even half the man that Clayton is. Clayton isn't honest, sometimes maybe too much. Good person. You are not. How would Laura prove that what is being said is not true if she has produced none of the documents to prove they are false? What is your opinion on her editing the sonogram on Fiverr? Gingras says, I don't get why people think Laura has no documents to back up her story. Actually, that's wrong. I do know why people think that. It's because certain folks have published false statements over and over, claiming that Laura has no documents. This is just only making Laura's defamation claim stronger because it shows how powerful a lie can be. People literally think that they're hearing the truth when it's actually lies. Where is the lies? Because pictures or pregnancy tests are not considered documents. A low HCG test and a doctored HCG test, they are documents, but they don't further her story. They further show that she wasn't pregnant. There are some sonogram pictures. Those have been doctored. So, what documents does she have that shows she's telling the truth? Her banner patient portal? Get me a stupid shirt that says, check my patient portal. I'll wear it around. Here's my login information. You want to look at my patient portal at Banner Health? Check my patient portal. They're not lies. As for Fiverr, I don't know what that's all about. Of course you don't. I think you actually do, and you like to play dumb. Just my opinion. Because the fact that you don't know about other parts of the case shows that you are not doing your job as a lawyer. Because you should immerse yourself in this case. You should know everything in this case. You should know all the things about the witnesses and past case that could be brought up for Laura's credibility. uh, documents. Like, you should know these things. They are relevant to her scheming. And the fact that you played dumb or you actually didn't go look at any of this stuff makes you a shitty lawyer. As I've said before, I'm not watching any videos about this case at the moment. Well, whether he actually was or wasn't watching videos at the moment, he has sense. I just don't have time to. I do have other clients. Who? Who are your other clients? I know you had a client for a little bit, and then I don't know what happened to that one, but you aren't on that one anymore either. I don't know what you have. If you can explain what the story is with Fiverr, I'm happy to look into it, but I assume it's just more lies from liars who keep on lying. Sir, you know what the Fiverr story is by now. You've been told it, but when we tell you things, you're like, oh, I'm happy to look into it and let you guys know. But if my client says she didn't do it, I'm going to believe my client said she didn't do it, even though I have proof that she has doctored things before. Yeah, no, you're not happy to look into it. You just ask your client, if she says, no, I didn't do that, you're like, she said she didn't do it. Okay, how about you look at the actual thing? They say, question regarding the explanation of defamation, wouldn't there be a concern of a jury not agreeing? Ding, 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 ding. Simply just seeing that obviously the public is currently not on her side. Yeah. And it would be, the jury would be built on people like all of us that live in her area. And nobody other than people that are related or just haven't looked into it for themselves and is just taking her word or is just taking Jan's word or is just taking Ron's word. Everybody that is just regular folks and strangers do not see her side. Nobody believes her. And usually there's some people that do. But no one that has looked at this case and looked at both sides and all the evidence and everything that's out there has ever sided with her, which is something truly unique in a case. And if that was a concern, could you do it without a jury? What would make you think that you could change in a defamation case related to the same issues? I was confused about this correct case not having a jury and if there was a reason why. It was an evidentiary hearing, technically, so there's not juries for evidentiary hearings. But Jinger says, I'm not sure I understand the question. In any case involving a jury, there's always a chance a jury may not agree with your position. That's the exact reason we have juries, so a group of people can look at a dispute and decide what they think happened. And when you have like a high profile trial, sometimes if you have a public that is against you, and basically, a lot of your evidence out there for your defense and stuff like that, and what the prosecution has out in the public, if most of the public doesn't agree with you, then that should be a good sign that a jury is most likely not going to agree with you. Because a lot of times in some public cases, we pretty much know what the defense has. The state keeps things to themselves, but a lot of times we know what a defense has and what a defense doesn't. Now, if you've kept your defense to yourself, then obviously hearing the state and the public has no idea any of the stuff because they choose to fight it in court and not in the public, that's a thing. But if a lot of your stuff is out there, maybe a jury trial isn't for you if the public is like, yeah, I've seen the state's evidence and I've seen what you've been putting out there. We're not buying it. And a jury isn't going to either if this is all you have. Is it safer to go with the judge because they're going to go on the law and not certain things? Yeah, I think that would have been better. Because Laura with the jury, it's not going to go well. Okay, this is also why Clayton's paternity case is actually in the wrong court. Family judge has no jurisdiction to decide civil claims like defamation. The judge didn't decide on words and things that hurt Laura's feelings or Clayton's feelings. They decided things that pertain to family law. Not, oh, Clayton said this and Laura said that. They didn't do anything with defamation. I don't know why he keeps saying this is a defamation case. It's not. This argument Laura's first lawyer raised properly, and it's an issue I will continue to raise in the case. Clayton is acting like this is a civil defamation case where Laura is the defendant. That would be fine, except for family court has no jurisdiction, basically, to rule on civil claims, especially when both parties have a constitutional right to a jury trial. This is an issue I'll be submitting further briefing on when the time comes. It was to discuss her behavior in the case thus far, and then she just continued her behavior. This was not a trial. It was an evidentiary hearing on sanctions. And is there proof that Clayton is the father? This wasn't an actual trial. And so that was all it was. Show me why you think she should be sanctioned. And, if that is evidence and all that, then she will be sanctioned. If there's not enough evidence to show that she should be sanctioned, she wouldn't have been sanctioned, but she was. This wasn't a trial. I know we call it a trial, but it was an evidentiary hearing for sanctions and other things in the case. The discovery would be, oh, wait, we're not going to read that. Okay. So, at the very bottom comment. So, David, I can testify that a mailman delivered the mail if I didn't see them. I can't testify that a mailman delivered the mail if I didn't see them. Even if there was no mail in the mailbox this morning, but there was mail in the box when I got home, and a mail truck parked across the street. Person said, serious question. He says, you're actually correct. If you don't personally see the mailman put stuff in your box, you lack personal knowledge of how your mail arrived. Which, correct, it could have been your neighbor. Maybe the mail got dropped off somewhere wrong and the neighbor did it. Maybe a dog, a male dog, put it in there. Maybe a robot mailman put it in there. You don't know. You assume the mailman did it, and that's a reasonable assumption, but you didn't actually see it. He says, but to be fair, this rule does allow for some flexibility. If you went to bed and the street was dry and then you woke up in the morning and saw the street was wet, most judges will allow you to say it rained last night, even if you never personally saw the rain falling. But on the other hand, the more important an issue is to the case, the less flexibility is given on the issue of personal knowledge. I am not kidding when I say this issue is so important. I've won entire cases based on a single witness lacking personal knowledge. Also, I'd like to hear about those cases in what the witness was saying and if it had relevancy or things like that. Because if it's just a bunch of hearsay, yeah, they don't have personal knowledge because they weren't there for it. They just heard from somebody that this is what happened. Like, they don't actually know. They just know based on this person's account of the story. The bottom line here is if one of Laura's ex-boyfriends claims she faked being pregnant, that person must explain how they know that. Clayton is trying to claim he knows she was never pregnant because I didn't actually stick it in. But that's an incredibly weak argument. This line gets me every time. Not having sex, not having intercourse is a weak argument for claiming somebody's not pregnant. No, I think that's a pretty good argument. Most people will be like, yeah, no, this bitch is lying. That is the usual circumstance. Could there be some exception to that rule or some rare occurrence when all the planets are aligned and stuff that something else could happen? Yes. But that's the exception, not the rule. Our expert with 30 plus years of experience will testify that when a penis, sperm, and a vagina are in close proximity, a woman can get pregnant without actual penetration. I bet you anything Clayton's own experts will agree with this statement. I get those are technical words. Why did you have to list them like that? A penis, sperm, and vagina. You could have said that in a less provocative manner. And yeah, of course, your expert with 30 plus years of experience is going to say this. He was around when the Virgin Mary got pregnant. It it's just it's a weak argument. No, I did not have sexual relations with that woman, as Bill Clinton said. I mean, he wasn't telling the truth, but Clayton is. Seriously? Oh, that's a weak argument. He says, when are you going to address her lying a little having ovarian cancer? He said, this is being addressed in a brief that will be filed in the court today, May 3rd. I will tweet a link when it's filed. Here's the link to the brief I just filed. And we've gone over that. And all this is happening like in the May 3rd time period. So very busy on his blog. This person says, I am confused. Laura's critics are going to face defamation. So you can't question, have an opinion, or be a critic of this apparently very entitled person without facing a lawsuit? Never knew someone was so special. Gingras says, you can absolutely have an opinion. That's 100% protected by the First Amendment. Knowingly spreading false information is not protected, and that is what a lot of people have done while talking about this case. Prove it. None of us are knowingly saying false things. We are reading court documents. We are giving our opinions and our views based on the documents and the evidence that we have seen, based on the words that she has said or written, based on your ramblings. So none of us are knowingly spreading any false information. And you can't prove that, and neither can she. And no one will agree with it, even if you tried to prove it. It's fine though. They will have their day in court, and I'm sure I saw it on Reddit will be a strong defense with the jury. Sir, that would be no one's defense. I saw it on Reddit. But if you want to go ahead and prepare for that as somebody's defense, and then they come in there and say, here's the court documents that I got this from. Here's the evidence that I have from court documents submitted in court. Here is the body cam footage I have seen. Here's the fake sonograms. Here's the stolen sonograms. Here is the arts and crafts. None of it would be, I saw it on Reddit. But you go ahead and prepare that, and you're going to lose that case even more. They're just going to come in here and say they saw it on Reddit. They just saw it on the YouTubes. Oh my God. Then there's another one he has questions about, and then he says, I'm not sure what your point is here. I've never threatened to go after any social media companies. I've spent more than 15 years defending the law, the Communications Decency Act that protects online platforms. He has done that he doesn't go after the platforms itself. And he knows that's not a thing. Like, he couldn't sue YouTube for something that Dave said. So I know better than anyone you can't sue YouTube because of false statements in a user-created video. He said, but you can sue the content creator themselves. Go for it. It's not going anywhere. If you post something false, you're responsible for what you said, and it's not a really strong defense to say, well, a bunch of people on Reddit said it's true, so I thought it was okay to trust them. Depends on what you have. Depends on what's on Reddit as well. If you saw court documents on Reddit from both parties, if there's something false in there, you're not knowingly saying something that's false. You're just saying what the court document says, and you're going off of that. This person says, name one false information that has been spread that you choose to follow. I will start simply. Are you going after Megan Fox, Legal Vices, or Mike Gravelin? I don't think it's going to be productive to go after Legal Vices as of now. Back in May? Might have been. Rest in peace, Jeff. Mike Gravelin, if y'all don't know who that is, he is Law Talk with Mike on YouTube, does a bunch of crazy court videos, and he accidentally stumbled into this, not even knowing what it was. It says, will you go after an actual attorney, real journalist, or just random online followers who have an opinion? I only say this because Gravelin laughed your client off online like an insect flicked to the side. Show some balls and go after them all. Gravelin made your client look so dumb it changed this case. Law Talk with Mike, when he did this, he just got a clip of a crazy story. And he didn't actually know who the people were. He didn't know it was like a former bachelor or any of that when he got this. And then it ended up turning into this huge story. And I actually didn't see his video until later when I saw somebody say Mike had done the video on this. Because I saw posts and stuff online about it, and then I had ran across Dave Neal's video, who I'd never heard of. I'd heard of Reality Steve, who wasn't covering this just yet. And then after finding it with Dave Neal and doing further investigation myself, I went and watched the Law Talk with Mike video. And it's funny that they don't actually, this person actually doesn't even mention Dave in this one. It just may not be one of the people that he watches. Law Talk with Mike he is funny and his reactions are funny. You may not always agree with some of the things he says, um, but it's who he is. It's his views, his opinions. He is an attorney, and so it's a great channel. And there are crazy, insane cases, and you're just like, if you enjoy people watching, you're just like, oh, if there are people out here in the world like this. Um, so you should definitely go follow him and watch his videos if you haven't. Are you afraid to face off with him? Who's Your Daddy videos brought most of the internet to this case. Why are you not after him? Gingras says he has no idea who Law Talk with Mike is. He's never heard of him. Um, Somebody, does a long comment. He says, Gingras says, when I post anything, I always post under my name. I would never post as another person and have not done so. That's totally unethical, and I'm not unethical. Um, I don't necessarily believe that because I don't believe that he's not unethical. He is very unethical. He tries to act like he's the almighty, you know, follows the law, and we're like, "Sir, we know you don't follow the law. We know you're a snake." No. And whether he has only posted under his name or he has created aliases, will we ever find out? I don't know. If he has, he has. If he hasn't, he hasn't. Don't really matter. All right. Now we're going to go over here to the second page, and it says towards the bottom, I am sure it will come out that she doctored the oophorectomy and ovarian cancer documents just like she did the sonograms. And I believe it will come out. And poor Mike and any other guy that listens to this. If someone tells you they have had an ovary removal or an oophorectomy, oofer is ovary, ectomy is removal in medical terminology. They are going to have scars to prove this. Most of the time. There might be some where they actually go in through your vajayjay and do it that way. But more than likely, they will either have one or both of these scars. One is at your belly button. You'll have a little scar there if they do it laparoscopically. Or you will have like a C-section type scar in your frupa area. All right. And they could have both. I ended up with both when I had my first ovary removed. They tried to go in and do it laparoscopic with through the belly button and stuff like that. And it was too big. I had a cyst on it the size of a softball that twisted, caused torsion, and had killed my ovary. It was all too big. So they ended up having to cut me open and then remove it that way. So I have two scars. And you will have to do some wound care and check on them. Keep it clean. All that stuff. So if Laura didn't have those after she claimed this, Mike might not know how they do this type of stuff, but they should have these things. They should also be possibly on pain meds unless they're just not a person that takes them. Um, and so that is one thing. And the scar won't be healed after they tell you that because You can also have that belly button scar if you've had anything done laparoscopic. If you have an appendectomy, which is the removal of your appendix, they can do it laparoscopic like that as well. Gallbladder, you will have that and some other ones, but you'll have that belly button scar. But if they've had a previous surgery, it's just going to look like a regular scar. But if it's fresh, it's going to be red. It's going to have scabbing and stuff on it. So there will be signs if this happens. Look for the scars. And Laura was always trying to get naked with these men. So they could have noticed, these scars. So if somebody tries to say these things, ask to see the scars. It's a telltale sign. All right, Gingras' response. Let's see what his response to this is. He says, let's see if you're right. Laura just filed an affidavit under the penalty of perjury, saying she had nothing to do with this stuff. If she's wrong, maybe you will finally see her thrown in jail. Yes, and we have. And she is wrong. She is wrong. If she's lying, I'd be the first one to say lock her up. Well, let's see. We are in the future now, and this is the thing. And you're not saying lock her up, you're defending her ass. So no, you're not going to be the first one to say lock her up. So that's a lie. But for now, I'm going to continue trusting her until someone proves she's lying. And I don't mean lying about a sonogram edit. She's already admitted to that mistake. So why is when she does something a mistake and not a lie? What is a lie to you? Is a lie something that you have to find out from somebody else that wasn't true? Omitting things, telling a different story, or if they omit, it's not lying. She just didn't tell me about it. So there wasn't even an option for her to lie about it. Like, or if you admit to lying, you didn't lie. Like, I don't get when he says that line because I don't know his definition of lying. And a mistake of editing things is not a mistake when you continue to do it multiple times. Going over to the second page on this one about that affidavit. Can we get a comment on the forensic report? Gingras says on May 9th, 2024, it's 2,500 pages, dropped 3 days before close of discovery. We are in the process of asking the court to exclude this because disclosure rules don't permit sandbagging. This is not sandbagging when it's in the timeline of discovery. What have been sandbagging is if at the hearing they said, hey, we have this 2,500 pages. We know you've never seen it before, but this says she's a liar. And you're like, I've never seen that. What is that? Y'all didn't disclose that. Or, oh, they just gave this to us today, Judge. That would be sandbagging. Giving it to you before discovery deadline ends is not sandbagging. Like somebody needs to teabag you, but that's a different type of bagging. Or alternately, we will have to ask for more time to conduct our own review of the new messages to determine if they are genuine. This is a process and we all need to follow the rules. They did. They disclosed it in the discovery deadline. Yeah, okay, 3 days before the disclosure of discovery. Let's say that instead of 3 days before the deadline, they gave it to you an hour before the deadline. Let's say the deadline was 10 p.m. and they brought it to you at 9 p.m., the last day of discovery. It still would be okay because it's in the deadline area. It's before it. You're so fucking sensitive. All right. Last comment on this one is David, what is your opinion of Ron Owens admitting Laura makes up stories and lies? That is documented in the text messages from Mike and Mr. Owens and Laura admitted it herself. Also, Mike said in his testimony that he never called her his sugar mama. Let's see what his response is to this. Gingras. I haven't spoken to Mr. Owens yet. I did meet Laura and her mom. Mr. Owens is apparently quite ill with Parkinson's, so I'm trying not to drag him into this if I can avoid it. Laura swears her dad has never said any such thing about her making up stories. Based on what I've seen of this family, I'd find it very hard to believe Laura and her mom are very close. Yeah, we agree. We think they're probably co-conspirators. Uh, and I understand that's true of the whole family. Yeah, I think those three amigos that live on that property are very close. I don't know about the sister. They might be too, but yeah, I believe Laura and her parents are very close. Laura's haters are trying to paint these people in a false light. What have we said that is false? We have just commented on the behavior that we have seen because there are videos that Ron Owens has put out. There are body cam videos of how Jan acts. We have the right to comment on what we think of their behavior. None of us have ever said, oh, we don't think any of them are close. No, it's too close. Too close that the parents can't even be parents. And okay, Mr. Owens says he's never said anything. I don't know if in his capacity he remembers he did. I don't know what he remembers and doesn't remember. So I don't know if we can quite take his word for something just because he doesn't remember it. He could also just be denying that he never said that. Since you've never met any of them, I'd ask you to reserve judgment until you hear the facts for yourselves. Well, we've seen them. Laura swears isn't a great argument from a documented liar and a person who has many misstatements, quote unquote. This was testified by Mike and Greg under penalty of perjury. Who would believe her? All right. So this comment that Gingras says here, remember some of the stuff he says here, because in the text that we're going to, or in a tweet that we're going to look at later in this video, it basically contradicts what he's saying right here. He said, but that's just the thing. It was not testified to by anyone under penalty of perjury, except for Laura. Mike never said he had actual knowledge of Laura faking anything. That is a lie that has been spread by Laura's haters. So nobody has testified under oath. Well, there are declarations that are given to the courts under penalty of perjury. There are depositions done under the penalty of perjury. So the fact that he says that nobody has testified to those things is a lie. He says, all that is a lie has been spread by Laura's haters. No. Don't take my word for it. Read Mike's deposition. I know the embedded version isn't easy to read, so here's a direct link where you can download it. And this is the link where he shared Mike Marraccini's deposition. Somebody said, why are you only sharing Mike's deposition? Why don't you share Laura's deposition? Yes, please. Oh my God, the tea. We need it. If you believe her, and believe that she's so honest. Gingras says, if this is appropriate, I'll post it. Well, why is it appropriate for you to post Mike's and not hers? Because she doesn't want hers out there? Because it looks very bad for her? Lots of more important things to deal with right now. Yeah, probably not. Drinking is not more important, sir. I know you think it is, but it's not. Another person comes back. I'm assuming it's the same person, even though the names and stuff are redacted and the pictures are redacted. Seems like you only want to tango with an audience rather than real lawyers. Where are your lawsuits against Mike Gravelin, Legal Vices, and Megan Fox? Not even a message to cease and desist letter. Are you afraid to go after the big dogs? Valid question. Gingras responds, I'm dealing with one issue at a time. It doesn't make sense to sue before our trial is over. Once that's done, the next phase will begin. And for the record, Laura is not interested in pursuing people just for commenting about the case in good faith. She's not going after people based on anything posted here. The concern is to go after the big folks who actively spread false information for money. Those are the folks we'll be talking to down the road. Well, that's why he doesn't contact me, because I'm not making any money. One day, I aspire to. All right. And he's not going to go after the big dogs. Everybody's reporting on this case in good faith, and we are not actively sharing false information for money. Even if I was making money, that's not, none of us are doing. Somebody commented on May 4th, 2024, you keep saying sonogram edit, quote unquote. However, you never explain where the sonogram came from. If you say Planned Parenthood, then you're not on top of your case. So where? Planned Parenthood Mission Viejo does not provide imaging. Where is the darn answer? Where? Gingras said, that is a completely reasonable question. Yeah, and if you could answer it, that would be great. But he doesn't. And the answer is both technical and a little complicated. No, it's not. It's Saturday evening, and we have some plans for Cinco de Mayo. So I'll have to answer this tomorrow. Well, tomorrow's Cinco de Mayo. This is May 4th. May the 4th be with you. You have plans on Cinco de Mayo, which is the next day. So why can't you answer this on the 4th and hope that the 4th is with you when we read your response? But no, you just don't answer. You're non-responsive, basically. But I do have an answer, and I'd appreciate reasonable questions like this. Yeah, but you never answer this crap. You never answer any of our questions, really. The ones that we really want answered. Really, the last part of the comment above on this first page, and it says, she was well on notice from the onset of this response that she knew or should have known her claims are false and frivolous. A lot of times, even in a strict procedure, courts don't always need the magic words to rule appropriately. Gingras says that I have a motion on this exact issue that will be filed tomorrow. All right. Then Gingras has this long post about a let's see, sum up this other thing. It says, you have mentioned that you could sue someone of these different reporters for defamation because they are knowingly spreading lies. Similar to what you said, could these reporters state the information they shared in good faith because of the information they had, meaning they truly believed that was the truth based on the information they had? I only ask because at least information I've seen them share does have proof with it. Now, the proof might be not completely accurate, but it's what they believe to be accurate. I guess to give an unrated example to help me understand it, would be like when people get on social media or the news and they say the president has dementia. Could they be sued for defamation? There technically isn't medical record proof that he has dementia, but people are stating this opinion based on the observations and things they've seen, and they do support it with their facts. I guess defamation as a whole really confuses me, and it seems to be something that takes away people's rights to share an opinion. It's a confusing argument for me in general because oftentimes the people who are spreading false information, whether it be defamatory or not, are being pretty mean, haha. But everyone has the right to be mean, I guess. And so Gingras goes to give us an explanation. Becca, who he has addressed before. So Becca is in here asking the questions and she is getting responses from him. To restate the issue, you asked a question that compared the issue of sanctions, a form of legal/financial punishment Clayton is requesting, with the possibility that Laura may sue some of her critics for defamation. The basic point you are trying to make is, to paraphrase, aren't those two things inconsistent? Specifically, I have argued and plan to argue at trial, the judge cannot punish Laura as long as she had some reason to think she might be pregnant. In other words, even if Laura made a mistake, and even if she was never pregnant, she couldn't be punished for making a good faith mistake. Nobody thinks it was a good faith mistake. It had ill intent, it was malicious, it was vicious, it was revenge. It was payback. Now her karma is coming back to her. Your question was, in essence, whether or why the same rules should apply to people commenting about the case. Put it another way, you are asking whether the law should protect people who said they think Laura faked being pregnant, if it turns out Laura wasn't faking anything. Aren't those people allowed to make a good faith mistake when commenting about the case, just as I have argued that Laura is allowed to make a good faith mistake when claiming she was pregnant? Yeah, but it's a mistake when Laura does it. It's just outright liars and unethical people that are saying things about Laura. But Laura's not doing any of that stuff. We are just the malicious ones, not her. He continues saying Laura has never said she wasn't pregnant. So she won't admit the case against Clayton was groundless. Yeah, that's her problem. Probably why she's not going to get a plea deal is because she isn't going to say she lied, even though she should. I think this is an excellent question, among other things, because you are right. It probably does look a bit inconsistent for me to say that Laura is allowed to make mistakes, but her critics are not. Yeah. I will do my best to explain my views on this, keeping in mind these legal topics are very complicated. Yes, because of all of us dumbasses that never went to law school could never understand anything in the legal world. Because you have to go to law school to understand simple things. I'm not saying the law is simple, but when it gets broken down, it's not hard to understand. You do some research, you learn about it. I mean, we don't think we're the all-knowing like he does, but everything isn't as complicated as he says. Oh, it's complicated. Everything is complicated. That's why there's so many books and textbooks and why you need a degree. Because if you don't have a degree in this, it's just you're too ignorant to understand any of this. And he said, I would probably take 100 pages of briefing to explain every aspect of this area of law. Here's the best response I can give you in a reasonably short format. I will do my best. Oh, sorry. First, you are correct, sort of. But the rules for court sanctions and the rules for defamation are very different, largely because damages caused by harm caused by bad legal proceedings are normally a lot smaller than harm caused by publishing false statements are usually minor, while harm to a person's reputation can be life-changing and often nearly impossible to repair. When it comes to punishing people for filing bogus court cases, as Clayton is trying to do to Laura, the law is very clear. People are allowed to make mistakes. Mistakes. Not purposely file things they know to be untrue. That's what you're getting at. Nobody believes that Laura filed this in good faith and just made a mistake about her pregnancy. Nobody thinks that. If we did, this would be a valid argument. But we think she filed it knowing she was never pregnant. That's not a mistake. That's vicious. That is actual malice. And she had forethought before doing it. It was all premeditated. Mm-mm-mm. This actually happens all the time. Sometimes a mistake is accidental and sometimes it's intentional. But either way, the standard for what a person needs to do in order to bring a court case against someone is very, very low. If you sue someone, yeah, because you can sue anybody, you can try to sue somebody for anything and everything. You can sue anybody. Doesn't mean it's going to actually go anywhere or you have a legitimate case or cause, but you can try to. If you sue someone, all you need is some basis to think your claims are valid. 100% certainty is never ever required. So long as Laura believed she might be pregnant, the court cannot sanction her. That's just the way the rule works. In a paternity case like this, a woman is allowed to bring a case simply because she hooked up with a guy and she just felt pregnant. There is no requirement that she have any sort of test first. There is no requirement that the pregnancy be confirmed or validated. One night stand and a single missed period is all you need. Laura had that, plus 5 positive pregnancy tests. I don't know if Laura missed her period or not. That could be another lie. Because you know that's something. Because guess what? There are people that don't have missed periods that end up pregnant. They don't know about it so soon. Laura acted before she should have acted. She could have waited till that baby was born. But no, she wanted the attention and her name in the headlines and to bash this guy and ruin his reputation. Okay. And I think that law should change, that women should not be able to bring this without valid and confirmed um, things. I don't think they should be able to bring it until they're past the first trimester. My opinion. You don't have to agree with me. She said Laura had that plus 5 pregnancy tests, including the one given to her by Clayton, which she took directly in front of him. That's a disputed fact as well. But let's ignore those facts. We don't even know if those are facts, sir. Those are just things that Laura says. What if Laura knowingly lied? Can she be punished then? The answer is kind of surprising. Maybe yes, and maybe no. Here's why. Because of the way our rules and procedures are set up, people are allowed to file cases they know are 100% false and fraudulent. I know it's shocking, but bear with me. People are allowed to lie on their papers. They can even commit perjury in certain situations. They're not supposed to, and they really aren't allowed to, because you can go to jail for that. I mean, I guess you are free to do that. That's where our freedom in America is you can make these choices. But just because you can do those things doesn't mean there's not going to be consequences for your actions. I know this because I've personally seen it happen in other cases, and it's even happened to me, as I explained in a prior post about the time when I was sued for paternity. That person had a good faith reason to believe you might have been the father. She didn't maliciously make up a baby. There was an actual baby in the picture. You happen to be one of the possible things that could have been that baby's father. Thank God for that child you're not. I I that woman did not have a good judge of character unless you were a different person back then. And I hope that baby's dad is 10 times better than you. But thank God you were not this kid's father. Because, oh my God. Yes, we have rules that say a court can punish someone who lies in their pleadings. Yeah, lying is not okay. Making mistakes is not lying. Lying is intentional. Mm-mm. But there's a pretty strict process that must be followed before any punishment can happen. The idea is that if a person makes a mistake and lies in court, the law wants to give a way of admitting fault and fixing the problem without facing life altering consequences. But she doesn't admit fault and she doesn't fix the problem. So the rules basically say if a person lies in their case, you have to give them a written warning first. Is that the case in all of them? Because if no one brought up Rule 26, and we didn't even have that as a thing. Clayton just stuck with the other sanctions that Judge Mata ended up actually giving, but no sanctions based on Rule 26. So in all of those other sanction requests, there is not a safe harbor provision. So in those things, she wouldn't have been given a chance to just drop it and not be punished. But she wasn't punished for not dropping it. She was punished for her behavior and lying and not handing over discovery. And all she was punished with was attorney's fees. She didn't get other sanctions. I mean, she got referred for prosecution, but that's knowingly lying and submitting false evidence. Or she's like, oh, I didn't submit it. No, but you knew it was going to be submitted and you still did it because you knew it was going to be used in court. So basically, says if person lies in your case, you can give them written warning first. You can give them the opportunity to fix. Um, says if you don't, the law literally says the bad guy cannot be punished. Period. And in this case, it is undisputed Clayton's lawyer never gave Laura the correct type of warning. The rules are very specific and they must be followed exactly. But Clayton's lawyer did not follow the rules. He basically admitted this. He he withdrew the motion, so it doesn't matter. But we know how much he loves Rule 26. He needs a shirt that says, I love Rule 26. This means Clayton cannot get sanctions against Laura, even if she lied, which she absolutely denies. I don't care what she denies. She does not have any credibility. Now, let me address your question about defamation. If Laura is allowed to bring a court case that turns out to be groundless, either because she made a good faith mistake or because she knowingly lied. But Clayton's lawyer failed to follow the necessary steps to get sanctions. Shouldn't the same kind of loose standards apply to people who talk about this case? Yeah, she would be bringing the case against us and we would just be defending it. So she would need to dismiss it because we wouldn't be the plaintiffs. But let's hear more of your argument, sir. Believe Laura lied, and it turns out we win the case by proving she did not lie. Well, you have not proven that to this day. Here we are, like 3 years later, 2 years later. Shouldn't that person still be protected against getting sued for defamation? The answer is, like almost everything in law, maybe it depends. Defamation is very complicated. area of law, but the main thing to know is that yes, the First Amendment does give you a very strong protection against getting sued. If you say something that is completely true, it is almost impossible to get sued, but again, there are exceptions. Yeah, you can get sued. Doesn't mean it's going to be a successful lawsuit, but you can get sued. Generally speaking, there are two main types of defamation cases: private figure defamation and public figure defamation. I don't know which one Laura would actually fall into. Because does she become a public figure because of this case? Or is she a public figure because she had a podcast? Or because her parents are who they are? Or because she was entangled with a former bachelor? Or would she be considered just a private figure? I could see arguments for both sides of that. If you publish something false about a private figure, someone who's not a celebrity or a politician, the plaintiff usually only has to show that you acted negligently. Well, we didn't have a reckless regard for the truth. None of us are negligently putting things out here. We're not making up stories that we don't have any proof for or things to support our reasoning for saying what we're saying. So none of us are doing that. That means you failed to do something that a reasonable person would have done. This is a very low standard. It basically means if you publish something false about a private person, you probably end up losing unless you can prove you did act reasonably. Again, super complicated, but relying on something you read on a blog or social media might not be reasonable in some cases, but reasonable in others. That's basically a decision that the jury would have to make. Well, we sought out body cam footage, police reports, court documents. We listened to both sides. How is that not acting reasonably and responsible and trying to confirm things that we're talking about? So that, once again, would not be our defense. Now, if the plaintiff is a public figure, usually a celebrity or politician, or if the speech involves a matter of public concern, the rules are different. In those cases, the plaintiff will have to prove the defendant had something called actual malice. This is where you would automatically lose because none of us have actual malice in doing what we're doing. None of us. The only person to me that has actual malice is Laura and you. The term has the a special legal meaning that is probably different from what you think. Actual malice means the defendant either knew his or her statements were false and they acted with reckless disregard for the truth. Reckless disregard is something higher / worse than simple negligence. Reckless disregard typically means the defendant intentionally ignored information that would have proven their statements were false, basically sticking your head in the sand and refusing to look at the evidence that supported the plaintiff. That's what y'all do. You stick your head, especially you, Gingras, you stick your head in the sand and are like, oh, that's from before my time. That's not the Laura that I know today. You aren't willing to look at or accept anything bad about her. You just put your fingers in your ears and are like, la, 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 la. You don't want to hear it because it doesn't suit your narrative. Where we look at both sides, we look at everything. There are things that we think Clayton did that he probably shouldn't have done. But he's human. He made a mistake. He shouldn't have gotten involved with a client. He tried to fix that error by passing her along to somebody else, telling her he can't represent her anymore. He crossed a boundary and a line, and he had consequences for it. And we don't agree with some of those things. So We can say, probably shouldn't have said that. I mean, there are things that Greg probably shouldn't have said, that Mike probably shouldn't have done. But we're not sticking our head in the sand and being like, nope, those things are things that make my person look not perfect. That's not what we're doing, but y'all do that. You don't want to hear anything negative or anything that actually proves that the justice for could actually be correct, because you don't want us to be correct about anything. So you just act like we're all lying when you know we're not. Based on these standards, I think it is fair to say that for most people commenting on this case, they don't have to worry about getting sued for defamation. You absolutely are allowed to have an opinion. Opinions are never grounds for defamation. You can even say you think one party is right and the other is wrong. What you cannot do is make factual statements such as Laura lied about being pregnant. No, we think, in our opinion, Laura lied about being pregnant. In our opinion, we believe Laura was never pregnant. There is no proof to say she ever was. He says, or you cannot say Laura did this to other men in the past. No, we think that Laura was never pregnant in the past. Because again, there is no proof that she ever was. Her stories do not make sense, they are not logical, and they are not based in reality. We don't ever say this for sure is a fact. It is based on our opinions, and all of us state that. Those are statements of fact, and they can support a defamation claim if Laura proves she didn't fake being pregnant and if the speaker has a correct mental state, either negligence or actual malice, depending on what future judge thinks should apply here. Yeah, we don't fall into that category, so it would be a loser of a case, and you'd just be wasting your money. The bottom line is that when it comes to free speech, people typically can make good faith mistakes and not risk liability for defamation. But people who spread false statements of fact because they want to earn money from advertising revenues are not engaging in protected speech. Where has anybody ever said this is the fact? They always say, based on the evidence, everything I've seen in this case, there's no way I think she was pregnant. Because I read this or I see this, I think, I believe, my opinion. None of it is stating that these are facts. They are committing intentional defamation, and it's seriously no joke. Nobody is intentionally committing defamation. These attacks have been devastating to Laura, which is why I'm confident that we would win. We will win the trial in June. You didn't. You need to quit being confident in your predictions because they never turn out the way you say. You're very bad at predictions. You should never play the lottery. Many of her detractors are going to have a lot to answer for. Yeah, well, bring it on. All right. Next question for Gingras is Dave. There are 2 questions I have not seen addressed in the filings or your post. Number 1, when did Laura learn she was having twins? 2, is she claiming the October sonogram is fake? He says on Cinco de Mayo, the day he had plans, Laura says she was told by Planned Parenthood that she was pregnant with twins. This was the ultrasound that she later admitted to editing to change the name of the facility. I don't know what you mean by October sonogram. To my knowledge, there is no October sonogram. That's because there are so many sonograms in so many cases. The October sonogram comes from a different case, I believe. That's not in this case. It's possible you're talking about one or more fake sonograms that someone else created and sent to certain online media people. Laura has denied having anything to do with those, and so far I haven't seen any evidence to the contrary. Go watch Judge Duty's video. There's your evidence to the contrary. Your own client, with her own mouth, says things. All right, next question on the second page says, will you be representing Laura Owens if the owner of the sonogram decides to sue her for falsely claiming the Vanishing Twins sonogram was her? Gingras says this isn't a valid claim, so I don't expect anyone will sue over it. Well, they could. And why is it an illegal claim? She's stealing people's medical records and claiming them as her own. I mean, it's not identity theft, but it's got to be something. Let's see. Somebody says computer and internet fraud. The act of defrauding could include altering or deleting records, accessing financial or other information, or obtaining something of value. Isn't a valid legal claim. Laura stole a medical record for her benefit. Several valid lawsuits are available through the Health Insurance Portability and Accountability Act. All right. Yeah, and then they mentioned the Dropbox, somebody, Jim, in the comments and stuff like that. So, oh, and he mentioned stolen identity too. All right, let's look at the next one. So you haven't seen her email sent to a podcaster linking the same ultrasound. Strange, because that was in the filing. Gingras says, hard to know what you're referring to, but my understanding is that someone sent an email pretending to be Laura that said, here is my 1,000,000,000% real ultrasound. And Laura has always maintained the email is fake. Yeah, well, she's also admitted that it's not fake. Somebody says, how about you take this down now because Mike wants you to. Gingras says he's never asked to take this down. He once again says the guy hasn't asked because people are like, take this down. Comment on the second page. Hi, David. Remember when your client lied under oath about having an ultrasound at Planned Parenthood, or is your brain too fried from your crippling alcohol addiction? Gingras says, when arguments drop to this level of mudslinging, it suggests the other side has nothing better to say. If you did, you would focus on that. Thank you for the lift. Is that like a cheers? Cheers for the lift. I will go have a drink now. I just want to dip down to the level for a little bit. All right, so those are the blog posts on that. Now let's go to the tweet exhibits. All right, so Gingras on May 2nd, he's very busy in May, beginning of May. This is going to require a full blog post to explain, but certain bloggers are already publishing more lies about Laura, so I'll just share this without full context. I'll explain later why, in my honest opinion, this guarantees a win for Laura. It doesn't. This is where he tweeted out the depo, and then the blog post comments we just read are from the blog where he talks about this deposition and his reasoning and explanations. All right. Then he makes a comment that says, oh, sorry, you're confused. When I said guaranteed win, I wasn't talking about the paternity case. I was talking about Laura's defamation case against people who published lies about her. And maybe he was, maybe he wasn't. He likes to move the goalposts and change his reasonings for things. This stuff is admissible in that case, and it will guarantee a Laura win, in my honest opinion. Yeah, your opinions don't matter. Let's see. Somebody says, bro, here's the thing. They keep coming with receipts, proof, timeline, and screenshots. You keep posting vague things and claiming they are bombshells and I guarantee when. Put up or shut up. Yeah, and he recently posted stuff about that even recently. So, yeah, he just is so vague. He beats around the bush instead of just outright saying and being transparent. The whole transcript is there. Read it. So, and then somebody put the comment, she dated Greg before Mike. She had a seizure with Greg, plus told him she had them since a car accident. Yet later claimed she developed seizures due to Mike's abusing her. Kind of sounds like a lie. Yeah, it does. One theme in Owens v. Eckerd is Laura lied about being pregnant with other men. Laura says that's 100% false. Liars speak in percentages. And several bloggers claim she's lying. I'm about to provide some receipts you haven't seen, which may change your mind about who to believe. Coming later today. And so this is part of the Mike Marraccini's deposition from June 13th, 2018. Question. So you were, just so I'm clear, you were aware that she felt conflicted about terminating that, right? Marraccini says yes. Okay, so Laura, I'm not clear about. Is it your position that she wasn't actually pregnant? Mike says, I think, I don't think she was pregnant 2 times. I think one of the times she made up a story, and I think one might have been legitimate. So he says might, not was, that he believed she was fully 100%, that Mike just believed everything. And he could have at the time and then realized by looking at what she did to other people he was like, no fucking way. That is what she said to me. That is what she did to me. And now is like, she was absolutely not pregnant. I don't believe it anymore. Where they could have remembered at the time and then they changed their mind and was like, no, I don't believe she ever was. Like, because this is too weird. Which one do you think is legitimate the first time? And why do you think she was pregnant the second time? He says, I think she did that to keep me around because I think she was going through a lot at the time. Yeah, he was on to her. Like, their relationship wasn't good. He probably wanted out of it and was showing disinterest, and she's like, oh no, I gotta reel him back in. Hey, I'm pregnant with twins. He was on to it back in 2018. This deposition doesn't prove Laura is telling the truth. It doesn't disprove what Mike believes now and things that he was thinking about then. He might not have been like 100% sure, as y'all like to say, that she was lying back then, but now he fully believes she was lying. All right. Then we have, and by the way, Mike Marraccini is one of the alleged ex-boyfriends who certain bloggers have cited as proof Laura faked pregnancies in the past. But here he is under oath saying he did believe she was pregnant. And by the way, she was never pregnant twice with him. He says hashtag justice for Laura. Oh, there's going to be justice. It's just not the justice that she wants. Somebody said, this doesn't make her look any better. I don't think you're doing her any favors here, which is fine by me. Hashtag justice for Laura's victims. Gingras says, this is literally her ex testifying under oath. He believes she was pregnant. Explain to me how that's not good for Laura. I'm sorry if the truth doesn't fit your narrative, but it's still the truth. It still doesn't show that he believed her 100%. He had doubts. And that's what that shows. He wasn't sure about anything. He wants to think that someone at he wants to think somebody couldn't possibly lie about this, especially the first time. And maybe she did the second time. She thought she could get away with it because she had ended up pregnant at first. But it doesn't prove that Laura isn't lying. It still shows she possibly faked pregnancies back then. Somebody commented he also thought she had ovary removed due to her arts and crafts just because he believed one of her lies doesn't help your case. Exactly. Okay, and then there is a picture of something from court that says, as petitioner's Rule 57 deposition on March 1st, 2024, petitioner testified, 1, she had altered an ultrasound image falsely claiming they came from Southwest Medical Imaging Smile. 2, she miscarried 2 hand-sized fetuses sometime in September or October. Gingras says, someone asked me for a list of lawyers I've sent to jail personally. Here's my response. Yeah, you know why we asked you that? Because you said you did. And we've read that blog on my channel. May 23rd, some comments about this week's ruling in Owens v. Eckerd. He has a blog about it. Also, FYI, I previously had pre-publication screening on for blog comments due to spam. I removed that and allowed comments without any moderation. This worked okay, but older comments were mostly low value, so I'm trying a 3-week time limit. Comments close after 3 weeks. You wouldn't have to do that if you weren't saying stupid shit. Gingras, sorry, initial link somehow didn't include the PDF extension. Here's the link. All right. Then on June 18th, so after the trial, many people don't know this, but to preserve or present objections at trial, a lawyer is always allowed to interrupt a witness verbally or with a gesture. It's called quieting the witness. And we've talked about this and how he tries to explain his hand gesturing. He said this practice is not just allowed and proper, it's required to preserve objections. You're not required to necessarily signal your client. If you prep your client properly, you won't necessarily have to do this. Like if you hear an objection, or if there's not a question being asked, you stop talking. You pause, the judge will make a ruling, and then he will tell you if you can answer or if another question is going to be asked. But he didn't prepare his client. I mean, he might have, but she don't listen. So he links this rule. Counsel should gesture to witness to stop and should immediately interrupt the witness by stating respectfully but loudly that an objection has been made. You didn't object when you were gesturing. That's a part of it. You have to object respectful but loudly. You just gestured and there was no objection until Clayton's attorneys were like, stop looking at him. Stop looking at his gestures. Then you were like, oh, blah, 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 blah. You didn't object when you were making those gestures. You were coaching her. I don't care what your lie is. It's all on video. You can see that you didn't do those things. But keep spinning the truth. FYI, I'm aware of the new Michael Marraccini evidence and I will be addressing it in due course. While that's happening, here's an odd flashback to Laura and Marraccini doing a podcast together, shared with permission. You had permission from Owens. You didn't get permission from Mike. You didn't know what this was going to do to him. This could trigger him. Somebody put all the best, or thing that says all the best, Mike Marraccini. When you've gotten through everything that Mike has been through with your client, then perhaps you'll be less smug. Gingras says, those are words, not details. Give me details. Otherwise, not helpful. She flew the kid to Iceland and Dubai. It doesn't seem like he suffered that much. Or are you fucking kidding me, Gingras? You sound like an abuser yourself. Well, I mean, I bought her nice things and gave her gifts. Like, he was nice to me sometimes, and then he was beating me the other times, or he was verbally assaulting me and degrading me and everything else. And he was, following me around, and I couldn't go anywhere. I couldn't talk to people. But yeah, we would go on vacations by ourselves. He would buy me things. We would go to dinner. So because they do nice things for you means that the abuse isn't that bad. Your life isn't that bad as long as you're getting to go to nice places. Seriously? Way to victim blame. And then somebody, oh, that's something else. Okay. And then somebody says, so glad it's so easy for you. Are you being deliberately obtuse about Mike's story, or do you lack empathy? He says, Mike dated Laura for 2 years. Almost the pregnancy part of this was like a minimal, if anything. That is what I don't understand. Even if she wasn't pregnant, this has basically zero impact on any part of their lives. Makes no sense to me at all. That's because you aren't these people. Somebody shouldn't be able to lie to you about that and put you through the torment that this woman put them through. All the texting and coercing that she did. Or manipulation, not necessarily coercion. She just plays mind games and throws tantrums because she's not getting what she wants. And somebody wrote, she wrote to the media, claimed grape, got speaking gigs pulled, tried to have his real estate license revoked, tried to have girls he didn't know served papers. So this person is talking about Clayton when the Post is talking about Marraccini. But yeah, she's done horrible things to all of these guys. And here somebody says, isn't he the one who can't get jobs due to her spurious allegations of abuse, that Laura Owens wanted to have a friendly chat, although she is afraid to be in the same courtroom? The one who was dragged into this against his will and had this picture posted by you on the internet. Gingras says, it was not personal. Or I was personally not present for any of the events between Mike and Laura, neither were you. As such, my view is I have no idea what happened between them. The fact you claim that to have knowledge is really troubling because you weren't there either. So how do you know who is right? You sound like Lori Vallow here. Gingras? Because that's her whole defense. You weren't there. No, nobody was there. You don't know what happened. You don't have any direct personal knowledge. You can't use social or circumstantial evidence to say I did something. You don't have proof because you weren't there. And if you're not there, you can't say I did something because you don't know. You sound like a murderer. How great is that, Gingras? Not a good comparison to be compared to Lori Vallow Daybell. You weren't there. Well, neither were the babies, in my opinion. And then, last exhibit is an email we went over before. This is where he's saying, if Mike doesn't cooperate with me in the way I want him to, I'm going to call the police. If he does cooperate, I won't call the police. Just like his client. Give me what I want, or I'm going to make everybody's life hell. And that's what he does. This is the one where he's like, well, if he wants to talk to Laura, no, he's the one that doesn't want to communicate, doesn't want to see her. But she's like, yeah, I'll talk to him. Bitch, please. Oh my God, these two people. They are asteroids. All right. In our true fashion in the Owens case, quote of the day. True ignorance is not the absence of knowledge, but the refusal to acquire it. And isn't this fitting for Gingras? It's the fact that he refuses to acquire the knowledge of factual things, evidence in a case, things proving that his client lies. He is refusing to acquire that knowledge, which is true ignorance. And that's why I say ignorance is bliss. He can blissfully and blindly believe Laura because he is refusing to acquire any knowledge that disproves his client. That's what makes him so ignorant. But here, with me, the loud little ducky, Mama Duck here, we don't have true ignorance. We seek out knowledge. We want to know all the information. Let us absorb the rules and the laws and the facts on a case. Let's look at everything. We want to absorb it all in like a sponge because knowledge is power. So, do not stick your head in the sand. Enjoy learning. We learn every day. Look for new ways to learn. Always look at both sides. And if you continue to do that, then you are doing good and you are being fair. Don't stick your fingers in your ears and la a situation, okay? Listen and observe and take it in. That is it for this video, and I will be back soon with another one. Hit that like button, subscribe, comment down below, and let me know your thoughts. Bye.